everyone, thanks for coming. I'm Amy Bishop. I'm a special counsel here, and Sandy Donaldson's joining me today as well, and he's a consultant at DW Foxtrapper. And we both work in the intellectual property space and privacy. It's about that. So as most of you aged care providers or other suppliers to the industry, you're going to be entrusted with some really sensitive information about the individual care and details that, if mishandled, would maybe lead to significant harm. And given today's digital climate, protecting your privacy of these people is more crucial than ever. But it is also important to understand how and when you can give access to the information. So today, Sandy and I will first provide an overview of the Australian privacy law, just generally, and look at some responsibilities of aged care providers under the Australian privacy principles, and then briefly cover the matters that must or should and commonly are included in a privacy policy, and some tips for maintaining security of personal information. And then we'll look at handling, disclosing and using personal information, including sensitive information, as well as obtaining consent and, importantly, determining who can consent. And Sandy will also discuss other situations such as permitted health situations. And finally, I'll be back to deal on data breaches. So we'll talk principally about aged care providers, but much of what we cover will equally apply to other healthcare providers. And also just wanted to mention that it's quite a complex area. It's really just a summary that we're giving today. We're happy to answer questions as well, but we could appreciate leaving it to the end. So privacy of individuals is governed by the Privacy Act. This is a federal law. Some states do have some legislation, but they generally only cover state public sector agencies because they're not covered by the Federal Privacy Act. In South Australia, it's called the Information Privacy Principles, and they're a binding policy just on those government agencies, but don't apply to private businesses. But also, I should have said, if anyone wants more food, I don't mind if you get up and eat. I'd rather. So if you guys want to eat, please help yourselves. The Privacy Act doesn't apply to all businesses. However, an organisation which provides a health service to another individual and holds health information, except in an employee record, is what's termed entity and will be covered by the Privacy Act. So a health service is defined, it covers a really broad range of services performed in relation to an individual, and that's things like improving health and also treatment of illness, disability or injury, and it does specifically include activities like that that are provided in the course of providing aged care. The second requirement is that the organisation holds health information. Health information is also really broadly defined. It includes information or an opinion about the health of an individual, as well as a person's expressed wishes about the future provision of health services to them. And also covered is other personal information collected to provide or in providing health service to an individual. So as you can see, most aged care providers will be providing health service to individuals, and will also hold health information about those individuals and not contained in employee record. This means most aged care facilities will have responsibilities under the Privacy Act as an APP entity, and so they'll be required to comply with the Australian privacy principles. Now, there are some other organisations covered by the Privacy Act, and they have responsibilities under the Privacy Act. They're businesses with an annual turnover of more than 3 million, credit reporting bodies, contracted service providers for Australian government, and businesses that buy and sell personal information. So they're all covered anyway. So an organisation with an annual turnover of less than 3 million is often considered a small business, and that's not covered by the Privacy Act. But if that business provides a health service and holds health information other than in employee records, it's not a small business, and regardless of turnover, it's an APP entity. So the Privacy Act governs the collection, use and disclosure of an individual's personal information. So personal information, again, is a very broad concept. It means information or an opinion about an identified individual or an individual who's reasonably identifiable. And this is whether or not the information or opinion is true and whether the information or opinion is recorded in material form. So essentially, this covers a really broad range of information or an opinion that could identify an individual person. So examples are just the name, signature, address, phone number, date of birth, credit information, even a photograph could be personal information, and IP addresses are also considered to be covered. And there's so personal information is a broad banner, and some personal information is considered sensitive information. And if it's sensitive information, it can be subject to more stringent guidelines for how you can use it. And so sensitive information includes information or opinion about an individual's specific things like racial or ethnic origin, religious or philosophical beliefs, criminal record, health information, in how we just talked about how that's been defined, and also genetic information that's not otherwise health information. And there are other things as well. They're just some of the relevant ones. So basically, any health information that an aged care provider collects or holds will be personal information, which is also sensitive information. So e-health records are sensitive information, and in addition, an aged care facility will probably hold personal information that's not sensitive information. So in this presentation, we're dealing with handling of personal information, sensitive information, as I've just defined, and just talked about their definitions. But a lot of this information will be confidential under the general law. And in that case, there's also another obligation to keep it confidential and not disclose it without authorization. But generally, if you're complying with the Australian privacy principles, which are commonly called the APPs, then at general law, things that are information that's considered confidential in nature and should be keeping confidential, you'll also comply with the obligations of general law if you comply with the principles, generally speaking. So as an APP entity that's covered by the Privacy Act, an aged care provider will need to abide by these APPs, the Australian Privacy Principles. These are contained within the Privacy Act. There are 13 APPs, and they govern the standards, rights and obligations around collection, use and disclosure of personal information, as well as an organisation's governance and accountability. They also govern the integrity and correction of personal information and the rights of individuals to access their personal information. So, for example, we've got APP1, that requires personal information be managed in an open and transparent way, and it also requires an APP entity to have a privacy policy. APP3 outlines when an APP entity can collect the personal information. And here the APPs distinguish between an organisation soliciting personal information and then receiving unsolicited personal information. And unsolicited personal information is dealt with in APP. So the summary of APP3, an organisation may only solicit, go out and get personal information that's reasonably necessary for its functions or activities. In addition to that, sensitive information can only be solicited and collected if the individual consents, unless there's an exception. Then we've got APP12, that sets out responsibilities for providing access to personal information, including health information. In most circumstances, an APP entity will need to give access to health information whenever it's requested by the individual person, or by another person who's authorised to request the access on their behalf. And Sandy's going to explain about who has this authority, who can consent. Generally, once you've worked out that, if the identity of the person making the request can be verified, there's an obligation that you have to provide the information, and likely you have to do it promptly within 30 days. There are some grounds for refusing access, but they're fairly limited, such as like if it's impacting the privacy of other people, or if access is going to pose a serious threat to the life, health, or safety of someone else, which could be in domestic violence situations with delay addresses and things like that, or if there's a risk to public health or public safety. There's also an obligation in APP 13, that's the bottom one there, to take reasonable steps to correct health information if a resident, say in an aged care facility, for example, requests a correction, or there's otherwise the organisation is satisfied that something needs to be corrected. So just some notes on that is that, like, out-of-date, incomplete, irrelevant, or misleading information can also be considered incorrect. And also importantly, like if there's a medical opinion that's expressed as an opinion, that's not necessarily incorrect just because the individual doesn't think that's or disagrees with that opinion. So as with providing access to information, in dealing with the resident's request to correct information, you have to verify their identity first. And also, if you're providing information to third parties, then you have to take reasonable steps to notify the parties of any corrections that are needed as well. So step from that to APP 1, which requires an organisation to have a privacy policy. There are certain matters that must be included in a privacy policy that are set out in APP 1.4, and they're the ones on the left. So you have to include the kinds of personal information that are collected and held by the organisation, and that might include the fact that sensitive information is collected, or if you don't, then you can say that in your privacy policy as well. You also have to cover how personal information is collected and held, such as you might collect it when a form is completed, and the purposes for which you collect, hold, use and disclose personal information. A privacy policy also needs to cover how an individual can access their personal information and how they can seek its correction, like what processes they need to go through for that, and also set out how an individual can complain if they think there's been a breach of the APPs, and how the complaint can be handled by your organisation and what their review rights are. And finally, you have to include whether the organisation is likely to disclose personal information to overseas people, and if so, if it's practical to specify the countries, then you have to specify the countries that you're sending information to in your privacy policy. So other than the required ones, there are some common ones, and generally your privacy policy should contain information just about how you manage the personal information that you collect from your organisation as a whole. But some additional matters that are commonly included are the circumstances under which you might disclose information to third parties. For example, if it's required by law, you disclose it to third parties, or some people might even list different third parties that they disclose information to. You could also include who, other than the individual, can access the personal information, or what conditions you might put on the access. And another one is information retention or destruction practices that are specific to your organisation. And also good to include sometimes is the process or schedule that you do for updating your privacy policy, and how you publish the changes that you make from time to time. And also whether, some people like to say whether cookies are used on their website to collect information. So once you have an obligation to have a privacy policy, you have to make it publicly available free of charge. Most people put it on their website. It's simple these days. And also just a reminder to update your policy every 12 months, and that way you keep connected with developments generally. So once an aged care facility has determined that it can collect and hold personal information, sensitive information, then there'll be obligations about handling this information and keeping it secure. APP 11 provides that an APP entity must take reasonable steps to protect the personal information that it holds from misuse, interference and loss, as well as from unauthorised access, modification, disclosure. So some things that might be done to satisfy this obligation are to put the appropriate IT systems in place, such as restricting access only to people who need to access the information, and you can close off from an IT perspective other people. You should also implement encryptions and multi-factor identification. And it can also be a good idea to own devices that are being used by employees to access personal information. In this way, like, an employer can have more control over the devices that are being used and also make sure that they're returned at the end. You should lock the server room and restrict access to keys. Or if your server's in the cloud, obviously check the security of that as part of, like, making sure you've got the right IT systems in place, and check its location. Because if it's overseas, then you have to include in your privacy policy that you're sending information overseas. If physical records are kept, then you can actually physically lock documents containing personal information in a safe or a filing cupboard. Sometimes it would be appropriate to have contractual arrangements such as non-disclosure agreements or confidentiality agreements, and that will oblige people, whether it's employees or subcontractors, people that having access to personal information that you hold, that will put an obligation on them to keep it confidential. You should also have appropriate policies and procedures in place, and also ensure the employees are aware of them and abiding by them during regular training is always a good idea. Human error is the second biggest risk factor for disclosure of personal information following malicious attacks. And with 30% of data breaches in the last 6 months of last year were a result of human error. So training employees on cyber awareness is really vital. There's also an obligation to destroy or de-identify information if it's no longer needed, provided that there's not some law in place that asks you to retain that information for a certain period. But particularly where the information is in a Commonwealth record, you might have an obligation to retain it. So to work out what a Commonwealth record is, you have to look at another piece of legislation, the Archives Act, and that identifies Commonwealth record as one in which is the property of the Commonwealth or of a Commonwealth institution. It was also records kept by a Royal Commission or a Commission of Inquiry that are no longer required for the purpose. And then there's certain other records in the regulations. But other than that, you have got an obligation to destroy or de-identify information when it's no longer needed. So this might mean putting in place like a data retention policy that outlines some procedures for identifying different kinds of personal information that you hold and determining appropriate retention periods to ensure that the personal information is promptly and securely destroyed once it's no longer required, or on the happening of certain events, such as like a resident leaving a facility. The Office of the Australian Information Commission, which is known by its acronym as the OAIC, is the body that's in charge of monitoring and enforcing breaches of the Privacy Act, and that includes breaches of the APPs. The OAIC has a wide range of powers, so it can conduct assessments about whether personal information is being kept in accordance with the APPs. It can make determinations about particular organisations, and it can accept undertakings by organisations. The OAIC can also be the body that applies to the court for civil penalty orders where there's serious or repeated interferences of privacy. At the moment, these are 2.5, or the fines go up to $2.5 million for individuals, And for companies, it can be $50 million or 3 times the value of the benefit obtained. Or if that value can't be determined, 30% of the company's adjusted turnover. And these are quite new entities that have been increased significantly in the last few years, as have some other comparable entities. So if someone believes that an APP entity isn't properly handling their information, then they can make a complaint to the OAIC, and they'll use their powers to conduct the assessment or investigate, and then they can apply to impose those penalties. So I'll now hand over to Sandy, who will take you through the specifics of handling, disclosing and using personal information, obtaining consent and permitted health data situations.
Yeah, I'd like to take a Jim or a bit both to address the legal something. So, go for it. So, way that APP entity, particularly an aged care provider, handles and manages and discloses information relating to an individual will depend to some extent on the nature of the information. To recap what Amy said, purposes of the APPs, information can be personal information or sensitive information. Certainly, the overlap between what Amy said and what I would say, but to reinforce some of the stuff. So, personal information, as has been explained, means information or opinions about individuals who is identifiable or reasonably identifiable, whether that information or opinion is true or not, whether the information or opinion is recorded in material form. Sensitive information, which is a sort of subset, like personal information, includes information such as information relating to racial, political, religious, philosophical, sexual, criminal information, or relevant, I guess, for our purposes, includes health information or genetic information that is not otherwise health information about individuals. So, use and disclosures. Handling of security arrangements, requirements for personal information, have been discussed by Amy. The APP entity needs to consider is how access is allowed to personal information and how the personal information may be used or disclosed. So the concepts of the APPs are collection, use, disclosure. We're talking about use and disclosure now. They're intimately related in connection. The OAIC, which we know as the Office of the Australian Information Commissioner, don't have any specific guidelines for care providers in relation to handling use and disclosure of personal information and sensitive information. It does have guidelines relating generally to service provider, which you may wish to have scattered. APP 6 to use and disclose their personal information. It's important to note the requirements of APP 6 relate to use or disclosure of personal information for what is called a second purpose. APP 6.1 requires an entity not to use personal information in its collection for a particular purpose. It is called a primary purpose or a secondary purpose, unless the individual has consented. There are some situations described in APP 6.2 and 6.3 which apply. Actually, I'll touch on those a bit just briefly later on. So it follows APP may use or disclose personal information for a primary purpose the information is collected. This takes us back to APP 1, which requires an APP entity to have an APP privacy policy, which must contain information, among other things, as to the purposes for which the entity collects, holds, uses, and discloses personal information. However, again, to recap what I only said, it's not sufficient for an APP entity privacy policy just to state the purpose for which it collects, holds, and uses and discloses the personal information. APP entity cannot collect personal information that is not sensitive information unless it's reasonably necessary for the entity's functions or activity. Sensitive information is directed to sensitive and the information is reasonably necessary for one or more of the entity's functions or activities. There are certain specific exceptions. 3.4. So, first information, other than sensitive information, explained via aged care facility or health service provider, collected by the entity, can be used for purposes that are disclosed in the privacy policy. The purpose disclosed in the privacy policy will be a primary purpose. The information that is collected is reasonably necessary or directly related to one or more of the functions of the facility, which is most likely pointed out in the privacy policy going to be later. Much of the information that was in the facility that will be collected by the facility will be sensitive information, particularly health information. But even if this information is collected for a purpose disclosed in the privacy policy, or otherwise disclosed, because there can obviously be a disclosing purposes for collection of individual privacy policy is the one we likely to collect up front. So, however, if it's disclosed some private the aged care resident whose sensitive information is collected still consent collection of the sensitive information. Consent is something shortly. We come back to APP 6. The aged care facility can use sensitive information internally and disclose the sensitive information to others, such as APP providers, for a primary purpose or for a secondary purpose if the resident has consented in useful disclosure. This suggests that whoever collecting sensitive information consent to the collection of sensitive information, which I said at the outset probably be in the privacy policy or by some other form of disclosure, which is consented to. It would be a good idea to obtain consent to the use or disclosure of the information for the right purpose for which the sensitive information may have been enriched. If consent is obtained to collection information, including sensitive information for a particular purpose, each of those purposes should have the primary purpose. Then necessarily consider whether any further consent disclosure. If an aged care facility or other leave service health provider wishes to use or disclose personal information, including sensitive information, for a purpose other than the primary purpose, that is, the purpose, then APP 6, as we've said, will apply. probably might if you could join me in a second. Maybe mainly to disclose if the purposes are adequately disclosed up front in the primary policy or otherwise, so that they're primary purposes. And possible possible secondary purpose, the disclosure of information for secondary purposes, direct marketing. APP 6 doesn't apply to direct. APP 7 applies to that, and it prohibits the use or disclosure of personal information for direct marketing, unless the individual would reasonably expect personal information not sensitive used for that purpose. It's also possible for an individual to consent to personal information, including sensitive information, direct marketing. Given consent is clear, and in its effect, reading repeats to the question not to proceed into material unsubscribed. Information is secondary. And the ministry is still possible in 6.2a. Use or disclosure may be permitted if the individual would reasonably expect the APP entity to use or disclose the information for a secondary purpose. And the secondary purpose is sensitive information directly related to the primary purpose, or if the information is not sensitive information related to the primary purpose. That is what the dividing line is between directly related and simply related. I'll explain. It's absolutely not clear, like a lot of this. Similarly, what an individual would reasonably expect is meant to be objective. That is what a reasonable person who is properly informed expect in the circumstances. But this, although it's meant to be objective, is clearly likely to be to a large extent subjective. Care should be taken as the cycles that only first information, if reasonably necessary, is used for disclosure. There's one example in IIC Gibson's what an individual may reasonably expect in a situation in which an individual makes adverse comments in media, but it's treated. AIC suggests that it's legally to expect the entity would then respond publicly to comments in a way that reveals personal information specifically relevant to the issues that the individual has raised, but again, not disclosing information that is not relevant. So it typically does mean that what is to be reasonably expected is not necessarily circumscribed to a narrow, but still pretty hard to work out exactly what in a particular case. Consent. Why? Consent is king. It will be apparent that pretty much anything can be done. Pretty much anything can be done by way of collection, use, and disclosure of personal sensitive information if consent is obtained. The individual with the information relates. The OAA does further say collection, use, and disclosure. It's similarly quantified by the CRAs from the APPs, and those are interpretation of the requirements by the office But I suggest it would be wise to have regard to all of the statements of AIC in relation to consent, to keep the AIC happy, which are really revised. What is consent? Section 50 of the Privacy Act defines consent. Means express consent or implied consent. There's no other guidance under the Act when the Act appears as to the meaning of consent. Well, express consent had to be see that rather verbal, verbal. There should ideally be some sort of record, although it might be possible to show verbal consent, witness from someone. And obviously, a written consent is more certain. Should ideally be acknowledged by the signature, either by hand or by electronic signature. Implied consent is a difficult thing. Although the OARC acknowledges that consent can be implied, it notes that this can only occur where a reasonably be inferred from the circumstances from the beginning that the APP is involved. So obviously it's preferable to have an express consent rather than rely on full slides. See, states that the entity must have express consent or have consensual information. This is not apparent from the APP. But in other matters, if this is the view of the OARC, any event with practice is probably wise to ensure that express consent is required to the sort of disclosure of sensitive information. The OAIC says 4 key elements of consent. These are that the individual is adequately informed or giving the consent. The individual giving the consent voluntarily. Consent is current, specific. The individual has the capacity to understand and communicate consent. Each of these elements can be installed with circumstances to achieve, and particularly if an individual somewhere a disability, it's maybe the case for residents in aged care facilities. So, particular reference to one terms bundled consent, which makes funds together ultimately requests or purposes for consent collections of personal information without giving options. Choose to agree which of them consent. You've already paid the terms of the first information essentially it's conviction set out all kinds of all sort of thing. So the typical or this is what it should be. If the sense of an individual who is a resident of it, we obtain a collection of sensitive information. So at the same time, we prove intimated to obtain consent, use and disclosure of the information as well as the collection. Consent would be specific in writing and signed by or on behalf of the individual, or could be recorded by electronic means such as video. That's the ideal. For an individual, who's resident in aged care facility and who might be under a disability, it might be there's someone else who can provide consent on behalf. Disability could be an attorney for the individual, appointed under an enduring general power of attorney during one when the general power of attorney is not perhaps the attorney for the person given attorney. It could be a guardian appointed by a guardianship law, guardianship discretion. Could be, although not likely so much nowadays, a guardian appointed during guardian will now repeal British Guardianship Administration Act, so that one can still continue in the state being worked by care directive or something. Or it could be a substitute decision maker appointed by an advanced care directive, the advanced care directive. The powers of a substitute decision not as extensive as attorney under a general power of attorney, and anything that the person is about. But the substitute decision makers' powers include powers to make decisions in relation to healthcare, residential accommodation arrangements, personal affairs. I think this will probably extend to power in relation to handling personal information. So where it first used to be the resident of the Irish care the facility should cite and return a copy of the instrument. Of course, see, such as power 2, that's 3, filter within study. The copy of the document being used certified for copy. No specific to this is really best practice. We're also no specific requirements as to being certified. True copy. Often reflected that there should be someone with authority, such as the JP, lawyer, the commissioner for affidavits, it's not specifically required, but can provide some assurance as to the validity of the certification. Sometimes suggested that a public notary can certify the copies. This for documents to be used in Australia. This is not necessary, and indeed it's not clear. We're very public, which is through the dealing with stuff like overseas. I'm very excited. We keep being told that by notaries and stuff. So if there's some doubt about the capacity of an individual consent, another authorised person isn't available consent, it would be advisable to the signature or the verbal giving of consent to be written by a medical certify that the person giving consent satisfies the evidence requirement and lined by the OAC. Six. Coming back. 6.2. Use or disclosure of personal information during sensitive information for secondary purpose. Mention can be permitted under these tools. 6.2. If required by law or court, or it's permitted in general situation, or if it's permitted health situation. With a general situation, it's defined in section 16 months. This is what situations which include things like infection, prevent serious threat of life, health, or safety, unlawful activities. Section 16B prescribes what are permitted health situations. These include situations where it's necessary functions, individual. Also things like research, where it's practical, time concentric. Well, there's obviously a very brief description of those last few things, general situation, health situations. It looks like there might be need to disclose personal information, ordinary personal information, sensitive information, then you refer to the APUs to I think that's something that's right. Now the breach. Wrap up.
So now we know like who and in what circumstances personal information, sensitive information can be collected, used and disclosed. We've got some tips on how to keep it secure. What about in the event of a data breach? As you'll know, there's been a number of high-profile data breaches in the health industry. There's the Medibank private one in October 22. There was also Australian Clinical Labs in February 22. Indeed, 22% of notified data breaches in the last 6 months of last year were from health service providers, and so that's making it the most common industry. With all this in mind, the best thing to do is to avoid a data breach in the first place. So talking about investing in cyber security to ensure all your systems are as secure as they can be against any unauthorized access, and putting in place the practical actions that we looked at earlier about locking servers and filing cabinets and things like that. Make sure your employees are educated, educate them all the time about the risks and how best to manage the risks, such as with use of unique passwords and restricting access to selected employees. An aged care facility also should be requiring disclosure from suppliers like other health providers about how they collect, use and store personal information that the facility provides them, and make sure that those suppliers are taking the same measures to keep the information secure. An aged care provider should also have a data breach response to look to in the event that its data is breached after you've taken all those measures, but something can still happen. And if you have a data breach response plan, that can assist in dealing with it appropriately. So data breach, when we're talking about data breaches, that's basically referring to any unauthorized access or disclosure or loss of personal information. So some examples of data breaches are loss or theft of physical devices, such as laptops and phones, or also loss or theft of paper records that contain personal information. There can be unauthorized access to personal information by employees, or inadvertent disclosure of personal information due to human error. For example, like an email that's sent to the wrong person. Disclosure of an individual's personal information to a scammer as a result of inadequate identity verification procedures is also another example of data breach. So where an aged care facility, which is an APP entity, suffers a data breach that could cause serious harm to an individual, then it's reported to the OAIC, and in some cases it's also reported to any affected individuals. So serious harm can come in the form of distress or financial loss. It has been reviewed, won't go into too much detail today. There are some exceptions to notification. So if you can take steps to remedy the breach before harm occurs, then you don't need to notify the OAIC. And similarly, if you lose information but it's returned or able to be recovered before there's unauthorized access or before there's serious harm, then there's no need for notification. So for example, if you do send an email to the wrong person, but you get confirmation back quite quickly that it's deleted and that's trustworthy source, then you don't need to worry about notifying that, even though it's technically a data breach. Back to the data breach response plan. This can assist by notifying the right people in your organisation really promptly and put you in the best position to contain a data breach. It will outline lines of communication within an organisation and specify responsibilities of the data breach team within your organisation. So what a data breach response plan needs to do is outline who to notify in the event of a data breach, set out how the data breach is best contained, assessed and responded to in a timely way, and how to evaluate risks and identify if you've had a notifiable data breach, and that will include outlining how to assess serious harm. And it should also explain the exact steps to be taken to prevent further breaches and to start repairing your systems. It will therefore be of great assistance to an organisation in promptly detecting and dealing with a data breach, and it will put the aged care facility in a position to communicate quickly with residents and families without scaring them too much, and also can be a good reputational impact as well. So a data breach response plan, you're not actually required to have one, but again, like Florence was talking about, the OAIC is suggesting that it's quite essential and it's best to sort of follow what they do. You might assist with the penalties to keep them on the lower end if you've got a data breach response plan, maybe even get rid of them altogether. But having one in place certainly assists you. Just wanted to give some summary key takeaways to consider when you're balancing access and protection of privacy. So I'm sure everyone's got a privacy policy, because that would obviously be point one. But in relation to your privacy policy, remember that you've set out the reasons for collection, use and disclosure of personal information and sensitive information, and review it every 12 months. You should make sure you have and regularly review policies and procedures for handling, destroying and de-identifying personal information, including sensitive information. Only collect personal information and sensitive information where reasonably necessary for or directly related to one or more of your functions or activities. So just make sure that link is there. And in addition, for sensitive information, make sure you have consent to collection as well. The best practice is to obtain upfront written consent to all of these things, the collection, use and disclosure of personal information. And when you're dealing with people who are not the individual itself whose personal information you have, then you should cite and retain a copy of the document which provides authority to someone else to provide consent. And finally, just switched on, have and regularly review your data breach report. That's it. Thank you.